Good morning, good afternoon, good evening. Welcome to this 9th CPLJ webinar. As most of you know, my name is Enrique Vallines. I am a senior research fellow at the Max Planck Institute in Luxembourg, and also one of the editors of the CPLJ project. And I am delighted to be your host this morning, afternoon, or evening, depending on where you are. Together with Burkhard Hess, Margaret Wu, and Loïc Cadier, we're very thankful to all of you for being with us, especially those of you who have not yet gone to bed and are still awake, or those who have woken up early just to be here with us. We have today the pleasure of having Professor Russell Miller with us. Professor Miller, hello Russell again. He is a true comparative lawyer, I think. He has a soul divided into the United States and Germany. He originates from the United States, where he graduated and studied, but he has spent many, many years working also in Germany, and he knows very well the German legal system and German legal culture. He is the J.B. Stombaugh Professor of Law at the Washington and Lee University, and currently she is working for the Max Planck Society as head of the Max Planck Law Network. We're very grateful for your presence, Russell. Thank you very much. We will structure the webinar in the classical way. We will start with a presentation by Russell. This will take us about 1 hour. Then we will make a short break of 5 minutes and we will move on to Q&A, to questions and answers. To participate in the questions and answer sessions, just please use the raise hand button or write your comment or your question in the chat. And without further ado, I hand it over to you, Russell. His topic of today is entitled Comparing Comparisons, a survey of approaches to comparative law. Thank you.
Thank you, Enrique, for the introduction to this group. I want to, of course, thank you and Professor Hess for inviting me to participate in the CPLJ. Our personal conversations around other meetings and at other events about comparative law have been exciting and enriching for me, and for that reason, it's so much a greater pleasure that I'm able to join this formal conversation with such a broad range of stakeholders and participants. So thank you very much. I want to thank the organizing team as well. Nicole and Elizabeth have been professional and supportive and patient with me. I should also note that I'm particularly thrilled because I think I can count this as my first ever talk in Luxembourg. Maybe I can count this in our new Zoom world. I'll say as a final word of thanks and greeting that I'm particularly happy to participate today in the context of the Max Planck Institute in Luxembourg, because I've been so deeply impressed by the work of the Institute during my 2-year tenure as the head of Max Planck Law. But I would say, for me, more importantly, I've been deeply impressed by the character and quality of the people that I've encountered from the Institute. So it's a special honor to be able to show some kind of gratitude and thanks for those many really pleasant encounters by making these remarks today. So I have the chance today to present to you a survey of approaches to comparative law. And I think that's a quite big assignment, but I recognize that it's also not something that sounds very groundbreaking. After all, many canonical comparative law textbooks and treatises seek to present the better known or most widely used methods of comparative law. Cambridge University Press, for example, will bring out the 3rd edition of Matthias Siem's excellent textbook in just 29 days. I think maybe with this crowd, I'm safe to admit that I have it on pre-order at my Amazon Prime account and waiting for its arrival. Seems fairly presents a range of methods used by comparativists, including functionalism, classification, legal transplants, postmodern comparative analysis, contextualism, and empirical comparative law. His is a smart and accessible survey of approaches to comparative law, and from my fondness from his work that I've already signaled, it might not surprise you to hear me say that it's my view you might have done better to spend your Friday afternoon reading his fine book than listening to my lecture. Uwe Kischel published his sweeping German language treatise entitled Comparative Law in 2015, and that was followed by a brilliant English language translation from Oxford University Press 4 years later. Kischel's book largely seeks to contextualize the world's most prominent legal families. And for that reason, it is an impressive exercise in the comparative law approach that is concerned with classification. But in the book's introductory sections, he positions his agenda alongside other approaches to comparative law, such as functionalism and comparative law and economics. These are just two examples of the large and rich body of literature offering surveys of approaches to comparative law. So rather than recapitulating and representing a slate of methods, today I would like to reflect on the fact of the many surveys of comparative law's methods, and to suggest a way of understanding the need for these surveys of our many methods. Why are there so many approaches to comparative law? How are we drawn to one approach over another? What are the consequences of our choice of method in this field? With those kinds of questions in mind, maybe it would have been better to title my talk something like What We Talk About When We Talk About Comparative Law Methods. As an introduction to the main part of my presentation, let me raise some points that emerge from the fact that there are so many ways to do comparative law. The surveys of the various approaches to comparative law expose the unsettled nature of our discipline. Why are there so many and seemingly ever new ways of doing comparative law? Seams and Kischel present the various approaches like options in a menu. These are the various ways of going about comparative study, and you're free to choose, maybe even mix and match them. These authors can't escape the gravitational logic of classification in comparative law. And both books make immense concessions to the legal family's tradition in the discipline. They also acknowledge, even if they don't quite completely embrace, the prominence enjoyed by the functional approach to comparative law. But the other approaches, these authors present them to us, and they tell us that they're interesting and productive too. Another point, what kind of scholarly enterprise permits its researchers to select their methodology from a slate of equally credible approaches? It seems to me that maybe that might be characterized as a subjective science, if that's not a contradiction in terms. The array of approaches to comparative law have led me to conclude that ours is a particularly teleological science. That is, our methods and our desired outcomes are conditioned by our purposes and our goals. And that brings me then to a final introductory point. What might those purposes be? I suppose there are as many aims for comparative law as there are comparativists. The aims haven't always been noble, to be sure. Some approaches bear clear evidence of ethnocentric or nationalistic and ideological ambitions. That suggests that comparative law is not only a subjective science, but that it is also a political act. Just the risk of that has led me over the years to caution my students about the politics of encountering other foreign legal systems. I have urged them to reflect on their aims and to pursue their work with modesty, to approach new laws and new legal systems with a sense of hospitality and openness. I should admit, however, that those appeals aren't always so inspiring to my students. Whenever I raise these issues with a great flourish and with great excitement, ask my students why they'll be comparing laws, often they just say something like, "This was the only seminar with any seats left in it, and that's why I'm here." But it's a question that is important and central to our work. And it's my claim that it likely determines the method we select, and thereby it determines the results our research will produce. It's my view that these points are often neglected. So I've left you with the question, what might our purpose in comparative law be? In fact, two aims for comparative law surface again and again. Comparative law is a space for a struggle between claims of universality in the law, on the one hand, and claims about law's social contingency, its particularism, on the other hand. I know that that is not a new insight, or that it is not even an insight with particular significance for comparative law. This dialectic, these antinomies, are a central concern of legal theory more generally. Theories about law's validity, for example, have long been divided between the universalism of natural law claims and the social contingency of positivism. All of you know well that we have Augustine and Bentham, Fuller and Hart, Dworkin and Raz. I raise all of this because it is invigorating to be reminded that these common ambitions for comparative law, universality and social contingency, mark our discipline as part of a legal theoretical undertaking as well. And it's not just me who sees these competing aims as central to the comparative law project. Seames and Kishel recognize this dialectic as well. Kishel addresses comparative law's universality on the one hand, and builds a theory of contextual comparative law to counter the consequences of the universal impulse in our discipline. Seames, for his part, devotes most of his book's second chapter to a discussion of the universalism that animates the functionalist approach to comparative law, describing what he calls comparative law's interest in finding commonality. The chapter concludes with a discussion of disciplinary critiques of comparative law's universalist orientation, including particularist concerns about Western centrism, contextual awareness, and accounts of law's policy implications. And we can always count on Pierre Legrand to get us to the point. He titled a chapter in his edited volume on comparative legal studies simply "The Same and the Different." There, Legrand insisted, in his characteristically pointed manner, in a very important sense, the recent history of comparative legal studies must be read as a persistent albeit not always adroit, attempt to identify sameness across laws and to demote difference to a modus deficiens of sameness. Is it too bold, then, to propose that comparative law provides a different geography and new materials for the legal theoretical struggle between claims for law's universality and law's social contingency? To advance that suggestion, I want to present a survey of approaches to comparative law that suggests that the range of methods are, in fact, dialectical pairings, methodological dialogues that take up these two ambitions. Before turning then to that survey, let me make a final point. I will begin this survey with the reminder that comparative law can operate in two separate dimensions, often referred to as macro comparative law and micro comparative law. Jaco Husa explains there is a macro comparative law and a micro comparative law. Customarily, micro comparison deals with specific legal rules, cases, and institutions that are conceived from a point of view of actual problems or particular legal conflicts of interests, whereas the macro comparison normally focuses on larger scale themes and questions. Systematization, grouping, and classification of legal systems of the world lie at the heart of macro comparative law. It deals with comparison of entire legal systems, not specific small-scale problems of a legal nature. With that reminder in front of us, I will present macro comparative law's methodological antinomies, legal families, and legal traditions. And then I will shift to the presentation of several micro comparative law methodological antinomies, including functionalism and critical comparison, legal transplants and law as culture, and if time permits, then empirical comparative studies and comparative law as a hermeneutic. We'll see. Maybe I can sustain the claims that I've raised here. But even if that ambition falls short, I'm happy to say that these are wonderful comparative law texts, inspiring to me. They raise questions for me about why and how we do what we do. For that reason, I'm pleased to have a chance to talk about all of them with you. So let's begin then with our glimpse into the possible methods of macro comparative law that I've framed as families and traditions. Pargendler offers a masterful survey of macro comparative law's tradition of taxonomy, the desire to map the world's rich diversity of legal systems by assigning them to classifications based on their common characteristics. All of you know that this is omnipresent in our discipline. So much so that it's fair to understand that this practice of relying on legal classification or classification of legal systems has colonized the life world of comparative law. Imagine thinking about, let alone teaching comparative law without making a single reference to the Roman civil law or the Anglo-American common law. Of course, this practice has permitted us to create pastel-colored maps of the world's legal systems clustered by color and region. What's interesting is that Pargendler notes that we might seem to regret this omnipresent, dominant practice in our discipline. She reminds us that when we use these legal families, we often refer to them merely as ideal types and not something real. She notes that James Gordley and even Hein Kotz now wonder if we can bid these classifications farewell. If that's the case, we still have to acknowledge their stubborn persistence and their utility for talking about relations within or between legal systems, especially as a pedagogical or policy tool. So rather than outright rejection or abandonment, it seems that comparativists' uneasiness with the legal family's practice have instead devoted themselves wholeheartedly and with great energy to refining or improving or developing and suggesting new systems of classification. But the question of whether we ought to be taxonomizing social structures like the law remains beyond our reach. Pargendler's text is a masterful survey of that history. The main framework for pursuing this agenda, as I've suggested, has been the notion of legal families. This borrows, as we all understand, from the study of biology. The suggestion is that these classifications can function like the tree and branch metaphor for understanding the biological world delivered to us by Linnaean taxonomy. And there's a deep history of this from long before the 1900 Paris Congress and projecting, as Pargendler shows us, from one generation into the next up into the present day. She does us the favor of noting the insidious ideological, ethnic, or nationalistic ambitions behind the legal family's practice in some cases. And her article makes a remarkable contribution in noting that in this long history of classification in macro comparative law, the notion, the concept of the civil law family and the common law family are late arrivals. She also then reminds us of the canonical status of David's grand systems, as well as the canonical status of the classification provided to us in the Introduction to Comparative Law from Zweigert and Kotz. Their systems often point to quite similar classifications. Many of these classifications, however, suggest some discomfort. When we read, of course, that David has fashioned one system of classification referred to as Western law in broad strokes, that is accompanied also by a category referred to as other in the legal classification system. But the regular appearing taxa in these systems are well known to all of us. The Romanistic legal family, the Germanic legal family, the Anglo-American legal family, the Nordic Scandinavian legal family, Far Eastern legal family, the family of Islamic law, and Hindu law, for example, from Zweigert and Kotz. I know this is all very familiar to all of you, so I'll offer the presentation of this possible methodology to macro comparative law and offer you the answer to the question, why would I suggest that this legal family's practice, this tradition, is an example of the universalist teleology of comparative law? That's a necessary question because, of course, it is obviously not universal. It's seeking to break the universe of law into a set of separate classifications. Different classes, different taxa. But it's my view that the universalizing, or maybe I would be better to say the generalizing impulse of the universalist teleology is present in two ways in the legal family's tradition. It suggests ultimately a single universal world of law into which properly framed classes fit like puzzle pieces to form the whole of the law. Even the classes, then, are put to the service of that universal dream. Secondly, the impulse captured by the universalist thinking in our discipline, remember, Legrand would call it the sameness impulse, is at least radically at work within each of those classifications. That it's accepted and expected to treat the systems placed in any one category as generally the same. These are the universalist qualities of that practice. In macro comparative law, it is against that practice that I turn to the work of H. Patrick Glenn. I don't think it's an exaggeration for me to call Glenn's book, Legal Traditions of the World, a masterpiece. In its 5th edition, as it ended in 2014, and is summarized in the handbook entry I provided for you. I know all of you have read it, and many of us have found ways to criticize Glenn's project. But there's one critique that I find to be wholly inaccurate. Some thought that Glenn was pursuing an attempt to merely reframe or restate rather than repudiate the Legal Families Project. And at a glance, the book's chapters, especially when you think of the classifications I presented to you from David or Zweigert and Kotz, might suggest that characterization. Glenn's book includes a chapter on the Talmudic legal tradition, the civil law tradition, an Islamic legal tradition, a common law tradition, a Hindu legal tradition, and a Confucian legal tradition. Sounds quite similar in ways to the agenda and the conclusions reached by the legal families practitioners of our discipline. But that understanding of Glenn's work is simply wrong. Instead, he argues for the abandonment of the taxonomic legal families practice, suggesting that it be replaced by the concept he calls legal traditions. What is Glenn's criticism of the legal families practice in comparative law? He says the old taxonomic project, the classification based on legal families tradition in our discipline, is both static and exclusive in ways that are not reflective of the real nature and character of law. To fix a legal system, both in time and against other legal systems, is to treat the law captured for that classificatory endeavor as though it is static and stuck in time. But Glenn understands that law is dynamic, and the thing that you might have pinned like a butterfly in your collection on the board is in fact a social phenomenon moving and changing, and will be something different the next day. Classification denies that reality. He's also troubled by the practice of exclusion that operates in the legal families practice, because it suggests that the systems clustered in any classification are against and uninfluenced by those beyond their classification. And this, Glenn tells us, denies law's inherent discursivity and dialogical characteristics. In this sense, Glenn says that legal families are flawed. The classification endeavor is flawed because it denies law's dynamism and discursivity. It's one thing to have criticized that tradition, but how does Glenn propose to respond to it? It is his agenda, as I read him, to invert our frame of analysis from attempting to fit whole legal systems into their legal family categories, instead to examining how legal traditions appear and interact within a legal system. That means his list of legal traditions, Talmudic, civil law, Islamic law, common law, Hindu legal traditions, the Confucian legal tradition, is not a set of classifications into which we would place legal systems, but rather an invitation to see in which ways and in what degrees those traditions might be active in a legal system. I am quite persuaded by Glenn's endeavor. That's led me to write, for example, about the way in which the civil law and the common law traditions mix and dialogue to uniquely shape German constitutional law, for example. This raises a bit of a challenge, however. It poses the question, what does Glenn mean by legal tradition? What is that? And I have to say, this is a weakness in Glenn's presentation of the theory, because he tells us merely that a legal tradition is normative information, self-identifying as such, that passes from one generation to the next. He reassures us that some of these traditions, that is normative information, self-consciously aware of its status as an epistemological community, surviving from one generation to the next, some of these legal traditions, in fact, operate as the old legal families. That's why the civil law tradition and the common law tradition and the Islamic tradition appear in his catalog. But once again, his interest in them is in this inverted sense. How is it that the civil law and the common law and the Islamic legal tradition, even the Confucian legal tradition, might be active in any single community, normative community? I've struggled to find a better way to capture an understanding of what a legal tradition might be. And I find John Merriman's response to, or portrayal of a legal tradition, quite useful in this sense. He tells us that the civil law tradition, for example, from his marvelous little book, that a legal tradition represents a community's understanding of what the law is, how it is made, studied, interpreted, and applied, the assumptions about the role of legal actors and the nature of legal institutions, where there is a common understanding for a community around those questions. It seems to me we have a legal tradition. And Glenn's challenge is to invert the old legal family's practice and to urge us to see those traditions in dialogue with one another in a particular legal system. Maybe it's clear why I would offer Glenn then as an example of the socially contingent or particularist teleology of comparative law. Glenn very categorically rejects the superficialities and generalizations that are necessary for the taxonomic project, based on his critiques of exclusivity and stasis. He urges us instead to focus on a discrete, extant entity or incidence of law, perhaps a national legal system, perhaps other systems, and to focus on the diversity and complexity, the particularism within that system. With that discussion of the antinomies of methodology around universality and particularism in macro comparative law, I'd like to turn to the micro comparative law project and its many methods, or some of its many methods. This is the most common form of our work, and it has given rise to a number of approaches. I can only present a handful of the methodological antinomies at play in micro comparative law. But here too, I hope to maintain the argument that the methods represent a dialectic between our discipline's two major impulses: law's universality and law's social contingency or particularism. I want to note, however, that as I turn my attention to micro comparative law, I must express my understanding that these two dimensions of our work aren't so cleanly or categorically divisible. Quite a lot of micro comparative law work relies on, or at least assumes the significance of, the insights of macro comparative law classification. It is common, for example, for comparatists to seek to account for legal families as a basis for the selection of the systems they'll include in their micro comparative studies. With that, let me turn to my first proposed set of antinomies in micro comparative law's methodologies. That is the dialectic between functionalism and critical comparisons. The seminal book, Introduction to Comparative Law, published by Max Planck's own Zweigert and Kotz, makes a definitive contribution to the macro comparative legal families project. Pargendler, for example, concluded, contemporary scholars typically associate legal family taxonomies with their most famous proponents, French comparativist René David and German legal scholars Zweigert and Kotz. Still, that is not even close to the most significant contribution Zweigert and Kotz have made to our discipline. Their book also describes and justifies the functional method in micro comparative law. And this approach to the comparison of legal phenomenon from two or more systems has come to inhabit the discipline so that, almost like an operating system on your computer or the default font selected by your word processor, we barely notice its presence anymore. That allowed Ralph Michaels, Zweigert and Kotz's successor at the Hamburg Institute, to put it this way: the functional method has become the mantra of comparative law. For its proponents, it is the most, perhaps the only, fruitful method. The debate over the functional method is indeed much more than a methodological dispute. It is the focal point of almost all discussions of the field of comparative law as a whole. Centers versus peripheries, mainstream versus avant-garde, convergence versus pluralism, instrumentalism versus hermeneutics, technocracy versus culture. All of this in our discipline, thanks to the functional approach. This orthodoxy of the functional method is curious, because if you read Zweigert and Kotz's chapter closely enough, they suggest that the discipline is still exploring its methodological possibilities, even as they articulate the method itself. They say, our discipline is pursuing trial and error, and they express doubts themselves about whether a single method could ever account for all of comparative law's aims, even as their proposed method seems to have done just that. It's my sense that that modesty is an interesting, deliberate, rhetorical setup for Zweigert and Kotz's otherwise rather boldly confident methodological assertions. This is what they tell us, that comparative law will revive legal science. And in doing so, it will erase law's jurisdictional bonds for work on law as a truly international phenomenon. And in doing that, comparative law will restore the integrity of natural law and at last introduce exactitude, objectivity into the study of law. I'm exhausted thinking of that agenda, and the spark that will light this fire is the functional method. And despite those equivocal terms at the beginning of the chapter, the method is in fact presented as a fiat. In fact, it's presented as a natural occurrence. The authors use the terms, it's obvious, or phrases like, we all know that this is how the universe of comparison works. And in fact, we all do know that that's how we behave in comparative law now. The functional method involves the search for different legal systems solutions to problems. That is, the functional method tells us that comparative law is the pursuit of the study of different systems, laws, problem-solving function. That method, that aim, however, is encased in a number of assumptions or epistemological demands that may or may not have been necessary to the method itself. Those assumptions include things like this. Every legal system faces essentially the same problems. Every legal system solves those problems in ways that might appear dissimilar, but are in fact nearly identical. At least, they say, regarding those systems of law that do not touch on a society's distinct morals or ethics. They caution that in order to avoid the trap of seeing the solutions that different systems' laws provide as different, comparatists must achieve objectivity. They must avoid unconsciously looking at the problem with the eyes of their system. And then, as we all know, they provide the basic rule of comparative law, which is that different systems give the same or very similar solutions, even as to detail, to the same problems of life, despite the great differences in historical development, conceptual structure, and style of operation. They go on. Developed nations answer the needs posed to the law in the same or very similar ways, presenting something that is almost a presumption of similarity. They tell us that this work requires, and I think this part of their project is often neglected, an engagement with the whole kaleidoscope of the legal system. That the search for a system's answer to the world's common legal problems requires the comparativist to dive deep into that context, to search for those answers at the intersection of social, economic, political, and legal forces. Because the search is to find that system's authentic answer to this, and solution to the problems posed. But once discovered, that system's solution should be extracted from its context. They use the phrase set free and stripped of its national doctrinal overtones so that it can be considered alongside all other solutions. I suppose I don't have to say much about why I consider Zweigert and Kotz's functionalism as an example of the universalist teleology of comparative law. Günter Frankenberg's marvelous text, Critical Comparisons, was an impulse for a remarkable conference on new approaches to comparative law that was held at the University of Utah in the mid-1990s. Comparative law, somewhat belatedly then, was catching on to the critical legal studies wave that was sweeping American legal education and scholarship. Even as Frankenberg and others who attended the conference were working to revolutionize the field, their critical approach remained a subaltern voice in comparative law. That cause was not helped by the gradual exhaustion of the fervor for CLS in the legal academy in the United States. With the ascendance of law and economics and the emergence of the so-called war on terror chilling critique, even in the academic sphere. For me, as an aside, one of the thrilling facets of the new, often inappropriately hysterical debates around critical race theory in the United States today is to see that whole scenario as a revival of the dreams and demands of the old crits from that long ago time in another millennium altogether. But even before this revival, Frankenberg's text had become a part of the comparative law canon, drawing a wide range of commentary into its orbit, such as Per Zumbanson's tribute, Comparative Law's Coming of Age 20 years after Critical Comparisons. The understanding of critical approaches will be familiar to all of you. Legal research should work to excavate evidence that law seeks to maintain the status quo and reinforce biases so that marginalized groups remain disadvantaged. Critical legal studies scholars aim to demonstrate the subjectivity and political strategy in the law, that is, that law is power. And they seek to reveal law's historical, social, economic, and psychological impact, that power produces winners and losers. Frankenberg's work is functionalism's antinomy, in part because of the dominant place functionalism has acquired. It must be one of the targets of a critique of the discipline. But in case any doubt remains, Frankenberg makes the point plain, arguing that comparativists must begin with a critique of the rationalist assumptions that comparison can be objective if guided by neutral reference, such as law's function. But more pointedly, Frankenberg challenges one of the central tenets of Zweigert and Kott's functional approach to comparative law. Where the Hamburg comparatists demand and insist on the possibility of objectivity, the Frankfurt critic worries that faith in objectivity allows culturally biased perspectives to be presented as neutral. So what's to be done? Frankenberg urges us to view the comparative law project as an exercise in learning, the development of knowledge for its sake. And to do this, he offers us two mechanisms: distancing and differencing. Distancing, he says, obliges us to become aware of one's assumptions, to resist the power of our prejudices, and to break away from our firmly held views when we approach the other in law. And this, in fact, is a kind of objectivity that he's appealing to. But it's an objectivity offset by the act of differencing, which calls on us not to project our way of the law onto the objects of law we study, to break the unconscious spell that our way of doing the law holds us to develop a practice and a sharp sense of diversity and heterogeneity. That is, differencing calls on us to allow the other in the law to speak for itself. This, of course, calls objectivity into question. Why do I offer Frankenberg's critical comparison as an example of the socially contingent, particularist teleology of comparative law? Maybe it's especially the ethical elements of his concern for the other that convince me of its particularist orientation. Distancing and differencing call on us to the active pursuit of realizing and respecting diversity in the legal systems we encounter. That necessarily contradicts the universalist ambitions. There's another set of methodological antinomies, that is the legal transplants and law as culture set. Alan Watson reports that when he first offered a manuscript of his book, Legal Transplants, to trusted friends and colleagues, my closest friends, to whom I attribute the utmost good faith, expressed outright horror and advised me to hide the thing. Of course, we all know that Watson did not follow his friend's advice, and instead the book published in 1974, and almost on script, it immediately stirred great controversy. The transplants thesis, however, has shown great staying power. A second edition of the book was published 2 decades later, updated and enriched with new scholarship, now at the head of a well-established method in our discipline. Watson's argument disputes the idea, perhaps most prominently linked with Savini, that there is a close, even defining connection between the law and the society in which it operates. To the contrary, Watson argued that the laws of one society are primarily borrowed from other societies, and that, therefore, most law operates in a society very different from the one for which it was originally conceived. Law can be regarded, he said, as especially linked to a particular society, but that particularity is contrasted, Watson says, with the law's common roots shared by norms, and that those common roots are the result of legal transplants, a rule or institution moving from one country to another, and that this phenomenon dates back to the earliest points of recorded history. Watson boldly tells us the history of a system of law is largely a history of borrowings of legal materials from other legal systems. As a method, Watson urges the comparativist, or maybe we should, in his case, should say the comparativist legal historian, to consider 3 forms of voluntary transplants. The idea that people move into a new territory where there is no civilization and they bring along their legal habits with them. The idea that people move into a territory with a civilization present, but it is similar enough to receive and assimilate some of the law of the arriving people. Or the case in which one society voluntarily accepts or adopts the law of another. Watson's focus on voluntary transplants, of course, evades or avoids the unseemly, violent, involuntary transplantations that have taken place over time. The history of colonization is one cruel example of that form of transplantation. It's worth noting that Ralph Michaels, mentioned once again, is leading a remarkable project at the Hamburg Institute to introduce the principles and ethics of decolonization to our discipline. Where does all of this leave Watson? Maybe it's not surprising that for a scholar who began his career focusing on Roman law, many of those historical transplantations have their origin in or were amplified by the Roman law. It's also easy to see why the book stirred so much criticism. Like Zweigert and Kotz before him, he used fairly strong, fairly robust rhetorical tone. He says it's an accepted fact that most of the law of all modern legal systems, apart from the Scandinavians, derives more or less directly from the Roman civil law or English common law. He tells us that thinkers in societies that are poles apart geographically, economically, and culturally just often agree on specific rules of contract law. And he says that rules of equal validity in 18 or more countries offer a substantial challenge to the view that law reflects all the changes of changing economies and all the diversities of diverse civilizations. Here, maybe as in some other contexts, it's easy to see why I characterize Watson's transplants theory as an example of the universalist teleology of comparative law. Here it is an expression of the reductive and universalizing nature of the attribution of all law everywhere to one or two sources that have moved among the nations. Pierre Legrand offers a rebuttal. He is, of course, an amazing force in our discipline. He is immensely productive, and he has clearly secured his place as the best known critical voice in comparative law. But to say best known is to portray that stature in favorable or perhaps neutral terms. In fact, Legrand is reviled almost as much as he is prominent. And much of that is earned. Often his smart, theoretically rich critiques descend into ad hominem attacks that approach or rudely cross the boundaries of professional civility and collegiality. But if you understand Legrand's project, it is an effort to save the very discipline from the risks and costs of the orthodoxy in our discipline. And if all of that is at stake, one at least understands his posture. And that posture means that he is tilting against the traditional approach to comparative law, and especially the discipline's leading figures. Over a long and strategic campaign, almost no major comparative law scholar has been spared. Of course, that means Watson also came in for his due. That allows me to ask the question, what can we learn about Legrand's culturalist approach to comparative law from his article, The Impossibility of Legal Transplants? First, Legrand exposes the extreme nature of some of Watson's claims. This is valuable service because, as I've said with respect to Zweigert and Kotz, Watson sometimes exhibits an unreflected confidence that actually detracts from his thesis. For example, Legrand asks if legal transplants that Watson theorizes really are so easy to document and to accept. But more than that bombast, it is Watson's logic and its consequences to which Legrand objects. If it is rules that move as part of a legal transplantation, then Legrand engages in a deconstruction of the concept. He insists that a rule matters only because it has meaning. And meaning, he explains, is mostly provided by an interpretive act that takes place in a specific context. And then he reminds us that interpretation is a product of preconditions and expectations determined by epistemology, history, and culture. Legrand explains that if a rule benefiting from a particular interpretive framework is transplanted to another community consisting of a different interpretive framework, then the rule's interpretation will also be different. And that means its meaning will be different as well. In that case, all that has moved in the process of transplantation is a mere form of words. This expresses a robust culturalist view that might even have made Savini blush. Legrand speaks of a French rule being the product of French activity that is typically French, that consists of legal Frenchness. He refers to law as a cultural form that is supported by essential historical and ideological formants: culture, politics, sociology, history, anthropology, language, psychology, economy. Law, the subject of our comparative work, he says, is a complete social fact. And he uses this remarkable reference to the distinction between our understanding of bread, brot, and pan, as an example of these differences in meaning relative to a mere form of words. Whether you're convinced by Legrand or not, I can certainly share the impression that the Germans I host in the United States do not find our bread to be the equivalent of brot. Absent all of that social contingency, Legrand tells us the transplant simply, in effect, does not happen. Once again, it should be obvious with respect to his strong culturalist claims that Legrand is an example of this social contingency, the particularist teleology of comparative law. Maybe he is its strongest representative. And maybe his flaw is in the dogmatic approach to his demands for a cultural sensibility towards law. I have one final set of antinomies, and I know I've exhausted you with an hour of conversation. Shall I present them and then we could take a break? Okay. Let me present then two final antinomies of the methodologies of micro-comparative law: empirical comparative law and comparative law as hermeneutics. The newly dominant approach to comparative law in the United States involves quantitative social science methods. Early examples of this development, the Legal Origins Project, largely involved economists working from the insights of comparative law's legal families tradition. That early effort was stumbling and disputed. But the agenda has found its footing. Spaman, whose text I recommended, along with comparatists from Chicago and Virginia, are now some of the leading voices in the comparative law discipline in North America. Spaman argues for comparative lawyers to resort to large sample quantitative research designs borrowed from other social sciences. He tells us that these large sample research projects can cover as many as 130 different countries. Obviously, he concedes this will require some narrowing. We will have to narrow the defined questions in our large sample research. We will have to neglect the extra legal aspects of the law. And we will have to focus on the norm as it stands at one point in time. But accepting those narrowings, these large-scale research designs will allow us to produce correlations. That is another way of saying generalizations about the law that can then inform policy or law reform agendas. He tells us, for example, that the generalizations, the correlations that will emerge from these large sample research projects can elucidate the likely effect of rules and therefore facilitate the application of the functional method. Spauman admits that these large sample quantitative research designs involve a loss of information. And he tells us that that is hardly desirable. So how does he account for that risk? First, he tells us that comparative lawyers' criticism of that loss of information should at least acknowledge that other social sciences have learned to live with that risk. These methods are deeply entrenched in sociology and political science, for example. He also says that the information lost by the narrowing, perhaps the introduction of even some error in these large-scale quantitative research projects will be compensated by the sheer scale at which the research operates. In the sense that what might be lost on one hand is accounted for or recovered or compensated for by the depth and richness of a broad range of new information made possible by operating at such scale. And then he reminds us, and this is an important note, that traditional comparative law studies, what he refers to as qualitative research, also suffer from deficient information and inaccuracy. That is, the traditionalists' critique of these large sample quantitative research designs, loss of accuracy, do not level those critiques from a position of perfect strength. He says the qualitative work we've all been doing may suffer, example, from unrepresentative sample or from selection bias. And we're nevertheless often reaching generalized conclusions from those qualitative studies in order to make the same kinds of claims about policy or law reform. He recognizes that some challenges remain. I have to admit, as I don't work with this methodology, some of his solutions to the challenges elude me. I don't mean that as a critique, it's just simply my lack of understanding of that particular approach. For example, he tells us where law evades direct measurement, seemingly as a concession to its social and dynamic character, these studies can resort instead to indirect quantitative assessment. I think this must be something like the sampling that takes place in polling, for example. But I would like to understand that better. He wonders whether a large sweep of the law can in fact be quantified. He tells us that it can be. It's just as susceptible to quantification as any other social phenomenon. He tells us that law can be determined and it can be encoded into simple, possibly binary variables. He says to reassure us that it's similar to the productive work of the Trento Common Core project, where qualitative studies are summarized and then counted to produce pertinent outcomes. And once again, he reassures us that whatever shortcomings may emerge, they will be, in essence, washed out by the large sample that produces credible, even if rough, numerical values. I place this in the category of the universalist teleology of comparative law because it suggests to me that law can be reduced to data points. That is a process that requires generalization and a claim of converged meaning that is suggestive to me of the universalist impulse. But if those who are appealing for quantitative work hope to introduce social science methods into comparative law, it begs the question, is the law a social science? This is an old and contested matter because the central role of interpretation in the life and practice of the law suggests that it might be closer to, or at least have one foot in, the humanities. To understand the laws, and with this I mean comparative laws, disciplinary space, and its methodological possibilities, it is useful to turn to hermeneutics, which understands how to manage the role of interpretation in knowledge claims. Demirli gives us valued insight into hermeneutics' view of comparative law. The law's placement between the social sciences, and in that case, its susceptibility to social science methodology, and the humanities, on the other hand, is complicated. The law might be regarded as one of the humanities because interpretation is so central to its function. This is why law was long associated with theology, the other field fixated with texts in classical university faculties. But law is not just the realm of the interpreter, that is the reader. Each of us is not free to interpret a stop sign as we wish. This suggests that the law's intended force raises the relevance of the author's intention, which might be portrayed as a social fact. That is the realm of social science. And it suggests that law might be susceptible to being counted, as in one of Spaman's large sample quantitative research designs. Demirli explains that in the social sciences, the subject, us, the scholar, and the object, that which is being studied, are both a person. In the humanities, the subject, the scholar, is a person, but the object is a text. The problem is that law fits both of these cases. That's why he recommends to us that a hermeneutics of comparative law would negotiate these challenges. Demirli argues by embracing the notion that our understanding of law must account for both facets in dialogue with one another. Law as fact and law as interpretive act. To facilitate this dialogue, Demirli urges comparativists to regard the law as they study the relationship between a whole and its parts, an aggregate of external, that is interpretive, and internal factual conditions for the law being studied. Both of these efforts require awareness of particular foundations, the nature and assumptions of the author, as well as the nature and assumptions of the reader, an understanding of the particular culture of both, an understanding of the particular context of both. Comparative studies viewed as provisional or preliminary knowledge is perhaps the best way to resolve or pursue this law as a whole of its parts hermeneutical solution to its disciplinary schizophrenia. These provisional works of comparative study will be added to and further developed as our understandings of both dimensions, fact and interpretation, deepen. It's that provisionality and the insistence on embedding the author and the interpreter that suggests to me that a law of hermeneutics, grappling with law's social science qualities and its humanities qualities, looks to me like a method connected with the social contingent or particularist teleology of comparative law. Even if they later seem to forget themselves, I want to close by resurrecting Zweigert and Kotz's claim that comparative law is no sick science because we are so at ease with our discipline's methodological diversity. Alongside my crude survey of several of these approaches, I hoped to suggest that the choices we make about our approaches likely reflect our underlying aims or intentions for our work. It was my bolder claim to wonder if those aims and intentions can be reduced to something like one of the fundamental tensions in legal theory: law's universality or law's social contingency. I look forward to the chance to talk about the discrete methods I've charted today, and maybe some of these big questions as well. Thank you very much.
Thank you so much, Russell, for this wonderful lecture, this dichotomy between universality and particularism and how it reflects on the different methods. It was very, very wonderful to listen to you. And we open up now the Q&A. And please, as I said, use the raise your hand button, or maybe you could also write your questions in the chat if you prefer. I see Professor Chase has already raised his hand. So Oscar, please, you have the floor.
Hello, can you hear me? Yes, good. Thank you very much, Russ Miller, and details that I have learned a lot from you, and I appreciate that. I do want to talk about comparative law with respectfully in a more, perhaps a limit, which is my own views with regard to the EU and the members of the EU that have been concerned very much about procedure in law. And there have been, as I'm sure you are aware of, there are different views about whether the members should have the same or only slightly of the procedures among them. And as you know, in the Max, there's been a lot of interest about that. Certainly Enriquez knows about it. But I don't want to get into that but only how would comparative law approaches looking at the EU, which does have different passes, and how would these different comparative ideas affect that or appear to it? Thank you.
So Russell, please.
Hello, Professor. Thank you for your question. I have to be careful to over generalize or characterize the nature of the EU project, because I understand it to be a complex, dynamic process itself. But a major component of the EU project, the European Union dream, has been about the harmonization of law, and certainly the impetus towards the convergence of the legal norms across the member states. And in that sense, it has been a very distinct contributor to the popularity, the growing popularity of comparative law. I say that because the different jurisdictions require comparison. But in that sense that I've suggested, comparison for a purpose, a dominant purpose of the EU project has been that of harmonization. So it's possible to see the European Union and its claims for the convergence of law as a similarity project, a universalizing project within that sphere. And in that sense, then the slate of possible methods available for the comparative law done by or for or in the European Union would fall on that side of my ledger, the legal transplant approach or the functional approach. And it is in fact that tradition in the European Union that has made our loudest and sharpest voice for the particularist impulse in comparative law, Pierre Legrand, a strident opponent of the European Union comparative law project. I don't mean to suggest his position on the political question of the European Union, but its comparative legal agenda, characterized as the claim for convergence, and therefore placing comparative law on that similarity universalizing side of my ledger, has made him a strong opponent of the European Union comparative law project.
Professor Chase, would you like to add on to your question or make an additional comment?
Did you ask me?
Very much, Professor Miller. I appreciate it, and don't want to further about it.
Thank you. So we now move on to Professor Kaisis from Thessaloniki. Hello, Professor Kaisis.
Hello.
The floor is yours.
Hello to everybody. Thank you very much for the invitation, and congratulations to Professor Miller for the excellent, high informative and critical presentation. I would like to put two very short questions. The first one, most of us know and don't agree about the concept, the existence of lex mercatoria, but on the other hand, there are some, not very many, but there are some arbitral awards based on lex mercatoria as an applicable law. My question is there any connection between lex mercatoria and the comparative law as you understand it? This is the first question. The second question is more general, and I would like to have your opinion if you think that a modern digital legal tradition is arising in our days all over the world. Especially the second question, the answer to the second question would be interesting very much. Thank you very much, Professor Miller. Thank you.
Please.
Thank you for your questions, and I have to add an additional thanks for the sun I can see streaming through the window blinds behind you. Here in northern Germany, we have several inches of snow today, so I appreciate the warm outlook you brought to the session. I will confess to not being an expert or expert enough in lex mercatoria to be able to, I have of course my own general understanding of it, but to deconstruct it and try to place it in this framework that I've developed. But my impression that it makes a claim about a generally applicable regime derived from the practice of distinct jurisdictions or legal systems would point it towards the universalizing claims of comparative law. Maybe because you're smiling a bit, that maybe I'm on to the right idea that lex mercatoria might contain similar DNA as the impulse towards a universalizing claim. And in that sense, I guess I would be impelled to try to place it in that spectrum of comparative law work. In the same way that something like the Common Core project seems to be a kind of contemporary model or development in the same line of thinking as the Lex Mercatoria tradition. I love this question of whether a new modern digitalization of the law might change all of this calculus, and it certainly will radically facilitate transplants of the kind that Watson was convinced of, and certainly then the universalizing quality of these large sample research, quantitative research projects. So the impulse is for me to wonder if digitalization in its own right, in its character, might somehow favor or prioritize universalization. But as a social phenomenon, I'm tempted to wonder whether digitalization itself should be susceptible to the same kind of particularizing claims that would inform that side of comparative law's agenda. That is to say, digitalization will look and act and behave and mean something different to different communities. So it, as a phenomenon itself, might be subject to the same tension that helped frame my presentation of these methods. Again, my first impulse would be to say that it would seem to favor universalization or the universalizing impetus in comparative law. But maybe we would come to see, and certainly some approaches to that as a social phenomenon would urge us to see it as a very particularized experience, particularized phenomenon.
Thank you. We move on now to Canada. Genevieve, the floor is yours.
Thank you very much. Thank you so much for that really inspiring talk, in a way, for those of us who are engaged in a specific project of doing comparative law. I wanted to maybe bring it a little bit closer to home for me. H.P. Glenn was my professor many years ago, but my colleague for longer than that, and even Pierre Legrand. And all three of us are, well, Pierre Legrand and I, both graduates of the McGill legal education.
I know that.
And
yes.
Actually, my question relates to that, because you talked about, in a way, the contingency, law is social contingency, but what about legal education and the embeddedness of the student, and how that projects towards their mindset in approaching comparative law? And so Pierre Legrand and I, both students who did common law and civil law, right, in the traditional division of those two, in the same, in a faculty where H.P. Glenn was a professor, in a country that has, right, common law and civil law constantly being informing itself, sometimes one more colonial than the other. And so learning about law in that context, I think, necessarily shapes the way that you approach a lot of these questions, and whether it predisposes you to a particular comparative law approach or not is something that I've often struggled with, to see that from an internal perspective. And so I wondered, and you, an American transplanted to Germany, and we know that a lot of US comparative law is actually from transplanted German scholars. And, maybe in Europe, it used to be more parochial, but with the European Union forcing students and scholars to think beyond their borders. So I wonder if you could speak to the extent to which these things. So legal education and let's say exposure to comparative considerations within one's legal education, what impact that might have on what methodology we choose to, or we turn to, and noting, right, that Pierre Legrand and H.B. Glenn went very different ways. So there's no predestined path, but
Yeah.
I thought your position might be bring insights on that. Thank you.
So, Genevieve, I love this intervention very much. I've often said that, you know, the best comparative law is being done by the Canadians who have been socialized in that vice that you've described of systems and education. So I appreciate that, and I've often imagined H. Patrick Glenn and Legrand in the same faculty space, and although they had very different habitus and agendas, you'll notice that I put them both on the same side of my ledger, so to speak. So I find an affinity, at least relative to this dialectic that I've produced. Yeah, so much of the lessons that I see emerging from these methods are responsive to your question about legal education or legal socialization. And we don't even have to really guess what Legrand might say about this, because he tells us, in fact, I think it's in the text that I offered for this session, that every one of us is already the French or civil law jurist in waiting long before we ever arrive even at the law faculty. That deeply socially contingent, culturally constructed understanding of the law is already shaping us long before we arrive at the law faculty. After having read that from Legrand, I began to wonder about this, and I have to confess that on one occasion I received a traffic citation for failing to stop at a stop sign. And when I went home and told my American daughter, I said, "Hey, I just got this traffic ticket." She turned to me and she said, is it really true, Dad, that you didn't stop at the stop sign?" And I said, "Well, we'll see about that, won't we, when we go to court and I dispute this. And if the officer doesn't show up, then, you know, the facts will be mine and I'll win the case." And I realized already I'm shaping her to be this adversarial common law lawyer in training long before law school ever starts. So those are some insights into the significance of socialization that I find convincing. But the researchers and those shaping the methodologies on the universalizing side of the ledger have a response to this. So of course, Legrand is sensitive to that, and Frankenberg is strongly sensitive to that. Make yourself aware of your socialization in your legal acculturation. So the question is, how do the methodologies on that universalizing side of the ledger try to account for that possibility? And what I find is that they make a resort to claims of objectivity, systematization, and the potential scientific character of our research. And without hoping to call them into dispute or to criticize them, that's their answer to the possibility of what you've proposed, this unique experience that you might have made in your socialization can only be responded to or remedied by universalist claims, by making a summons to the possibility, the dream of objectivity in our work. And I don't even have to suggest that that's their impulse. They say it very clearly. We will strive for objectivity, and that will then suppress and make irrelevant the experiences that you were describing. In fact, they might suggest that those experiences that shaped you would be a barrier to the achievement of that dream, the hoped for scientized approach to comparative law. Now, whether you accept one or the other, based on your culture. Those would be the claims about one's position in the law, but whether that preconditions a comparativist for how she might, which side she might choose, you're right to note that there are a lot of Germans on the universal side of that schedule, and so that might suggest to their socialization in the notion of Rechtswissenschaft and legal science and that possibility. So that would be a set of possible thoughts on that question.
Thank you. If you will allow me just one last point. At McGill, we tried in a way through our legal education to overcome to a certain extent sort of that coming into legal studies with a particular viewpoint. And that was through our trans-systemic education, where students from the first day they're in, right, they see different, a bit of functionalist, right, different responses by different legal systems. Again, sounds a bit traditional. And so to overcome the feeling that, you know, you learn one's like a language first and everything is the other. I'm not sure to what extent we're successful in doing that, but it has been an attempt to overcome, right, this positioning, allow our brains to be a little bit more flexible. Thanks.
Well, what I'm suggesting, I think, is that you've been immensely successful in fashioning your own distinct community of understanding, which is able to embrace and navigate the idea of two dialectical or dialoguing systems, which is not typical of other educations in the law. So rather than your attempts to overcome the embeddedness may have fashioned a very distinct but unique approach and socialization. The other thing I will say, just based on your apologies about the potential functional sounding agenda that you might have had, is that I will say that, and I tried to qualify this in my presentation of the functional method, all of us, I have not found it possible myself to escape the functional method, or I should say the functional method's problem orientation. The question is, can it be separated from those much grander claims about the necessity of law similarity? And in that sense, I've tried to disaggregate the functional method a little bit, because I'm not able to escape the logic of posing a question, asking how different regimes respond to it. That there is a natural quality for me in that, but that can be pursued, I believe, in a couple of ways that evade the harshest elements of those really strong claims about law's similarity. So, for example, I was reflecting on a prominent edited textbook or casebook, we would call it in North America, on comparative constitutional law. And it seemed to be a rather functional methodology informing the project. That is, it was a presentation of constitutional law reactions to specific problems around and each jurisdiction's response to specific problems. And the first problem presented was the abortion question. And it struck me that that is a distinct constitutional law problem. And it's clear that many jurisdictions have grappled with and responded to that. But prioritizing it as the first question presented in the book seemed to miss the distancing and differencing claims that that Frankenberg poses to us. That the logic of posing problems was valuable, but allowing maybe each jurisdiction to present the problem most relevant to it, rather than imposing the problem that was obviously most on the mind of the editors of this book. I guess I'm trying to offer that as a way of saying that I continue to find maybe inescapable utility in the functional method without and hope that I'm able to avoid the more severe parts of the broader claims of that school.
Thank you very much for this interesting debate. We are going now back to Europe. Sabine Hackspiel, please, the floor is yours. You're muted, we can't hear you, sorry.
Can you hear me now?
Yes.
Okay, I would like to, first of all, to thank you for this really very inspiring lecture and overview of the different approaches to comparative law. Coming to the question of Professor Chase regarding the EU, I have been working inside the EU for several decades and dealing with comparative law a large part of the time. How should I say? Comparative law, of course, is at the core of what the European Court of Justice does.
Correct, yeah.
And the service that I had the honor to work in for quite a long time sort of gave support in comparative law to the judges upon their request. Now, completely unapologetically, I would say our method used to be functional. And I think it's really about, as you said, what the purpose of the operation is.
Yes,
yes. We had a very practical purpose in concrete cases to see how did member state laws address certain questions. The purpose was not necessarily to find a common solution that the court would then follow, but on the one hand, to give inspiration of possible solutions, and also on the other hand, maybe sometimes to have a sort of impact assessment. So if the court invalidates, or not, of course, the court never invalidates anything national, but if the court would say that that European Union law was to be interpreted in a way that certain national rules would not be compatible with it, then it would be interesting to see the rule in question that was before the court. Was that a complete outlier of the whole range of possible solutions? Or did maybe a majority of states see the necessity for functionally similar rules? So there was a sort of this very concrete, practical purpose of what the comparison sought to achieve. And I think for that kind of thing, the functional approach is really the one that needs to be followed. But I would say without preconceptions, without parting from the principle that you have to find the similarities. I don't think that was the case at all. The case was to look at similarities, but at least as much as at differences. So I think that's, how should I say, we would never go to the extremes that are attributed to the functional approach in the sense that in the end, everything's the same. And I must say my experience didn't show that in the end, everything was the same.
Well, this, if I was remotely inspiring, I'm grateful for that, but this intervention is the intoxicating and inspiring kind of report that makes me so envious of my comparative law colleagues in the continent. Of course, there was a period in which comparative law was almost made illegal in the United States in this period when the Supreme Court flirted with some comparative analysis. And but you also confirm, so I've always understood the European project as requiring and serving as an impulse for comparative activity and comparative expertise and the refinement of these methods as you describe. But of course, as you note, it is a political project, and it has and I don't mean this as a critique, that is a fact about it. It's a political project, and therefore its undertakings have a teleology, have a purpose behind them. And that will dictate, as I was suggesting, the kind of methodology that has to be chosen. I was lucky enough to get some glimpse into this with a period of service I performed at the court in Strasbourg, which has a similar unit, the research unit that conducts comparative analyses. I was interested to hear that your reporting served largely as sort of interpretive for the benefit of the deciding judges, whereas the Strasbourg court's search for a common constitutional core as a doctrinal matter seems to make its comparative work a bit, have a much seemingly a stronger impact, and therefore, in my view, ought to elevate the sensibility and the delicacy with which the comparative method is conducted in Strasbourg. So that was an interesting distinction for me to hear there.
Thank you. We stay in Europe, Germany, with Katharina Böhle-Bülke, please.
Thank you very much. And thank you also for the survey of various comparative law approaches. Given your introduction and the reference to your students, I also would like to ask a question about legal education like Geneviève did, but I have a more practical question. I was wondering how and whether you teach comparing comparisons to your students. I, for instance, use this title for an exercise in which students present to their fellow students previously selected comparative studies. And they should at least be able to answer various questions, such as which jurisdictions have been compared, or why have these systems been selected? Who has gathered the information for each jurisdiction? Does this study really contain a comparison? Are differences and similarities explained? Does the author evaluate the various solutions? How has the research been presented simultaneously or successively? On how have the research findings of other disciplines been used and incorporated into the comparative study? So this is a very practical question, and I was wondering how you are doing it. Thank you.
My first instinct is to say I want to sign up for this class if it's not too late to be enrolled for this semester. The second, it gives me maybe an opportunity to say that that at least from the particularist side of my methodological ledger, we would be obliged to take account of the distinct cultures of law students and lawyers and in the two systems that we're corresponding with each other from. And with that in mind, it was only a bit of a joke to say that students come reluctantly or only by second hand to a course on comparative law in the American context. Whereas I can imagine that that is a much more mainstream part of a legal education in the European context. And with that in mind, with that parochialism of the American legal education system and American law in mind, I'm much less open textured about my presentation of methods to my students. I have a concern or a fear that they won't come prepared for those modest, open encounters with the other. When I refer to the other here, I mean other legal systems, that there will be the impulse towards American exceptionalism that will cause them to merely reject or disregard those. So I much more heavily prioritize or emphasize just those socially contingent methods as I work with my students, because I have the sense that I have to account for their conditioning for exceptionalism and parochialism. I wouldn't
you.
want to suggest to a bunch of American students that we can universalize the law. Maybe their impulse would be to suggest that we should just universalize it as American law. I think they have that instinct already. I don't have to train them for that.
Okay.
Yeah. So but that is, I should say, is a conscious choice. As you can see, I'm aware of the menu, and I have my own views and passions about the two possibilities in our discipline. But I make a conscious choice to prioritize something like Frankenberg and a cultural sensitivity in the law for my particular students.
Thank you very much.
So we were supposed to be finishing by now, but Russell, if you don't mind, we could continue for a few minutes. Yes?
Yeah, please.
Great. So now, Burkhard, we're going to Luxembourg. The floor is yours.
Yeah, thank you very much for this journey we made with you through comparative law. I have 3 points I would like to address. My first question goes a little bit back to history. Is comparative law a little bit a product of the 19th century with codification and building up the nation state? It looks like. But you also told us that it has, and this is my next point, it reflects general methods of legal theory of different times. So we could see that over times it has taken up some major trends of legal theory and methodology. And this brings me a little bit to CPLJ, our project here. And you took up the idea of the social contingency as opposed to universalism. I'm wondering whether we are doing here something a little bit different, because all people in these projects are in procedural law. And maybe we have a common understanding, at least to some extent. This is a presumption or a starting point for the whole project, that we are able to formulate questions which finally are important for us, dealing with dispute resolution in general and in civil proceedings specifically. And in this regard, I'm wondering to what extent we can overcome this social contingency by a different contingency, which is procedural law. And then I would say, of course, we have for each generation the task to map a little bit the world new. And this is the idea of the different legal families. I was really fascinated by the different outcomes regarding legal families over years, but I would not be surprised that in 15 years, we will end up, or others will end up in different categories. So it's a little bit my question to you. How do you see CPLJ coming from other regions of comparative law?
Well, I am really honored to have been invited amongst the proceduralists here, but I can't claim to have the expertise that all of you have in that particular discipline or subfield of our discipline. With the exception that I will say that on 2 occasions, I was responsible for teaching procedural law matters. In the United States, you are all very well aware that a big portion of criminal procedure is constitutional law. And so I've had the privilege of teaching constitutional criminal procedure. And in some sense, you can call yourself a proceduralist, but you're really a public lawyer teaching constitutional law. But I had another experience. My dean in my early years of teaching came to me and asked me if I wanted to teach civil procedure or conflicts of laws. And as a public lawyer, I thought both of those were a little outside of my reach. And I said, well, neither. I really don't feel qualified. And he said, good, you get to teach both. And so I hurried to try to learn some civil procedure in the American context. that's the extent of my entitlement to speak about procedure in this community. But I would love to hear from all of you about whether you share the sense that that procedure eludes the claims of the particularists, the social contingency orientation of legal theory, and then I say of comparative law, or if it's the sense that in fact it is somehow uniquely susceptible to the claims of the universalizing impulse in legal theory, and as I say, in comparative law. My sense is that procedure is has deep local meaning just as much as substantive law does. And that's coming from someone who's used to seeing jurors, for example, sitting on civil law cases and huge, pecuniary damages decisions driving the procedure. And of course, the whole story of discovery as a procedural matter. Those all seem to me to be deeply contingent in a particular context. So that would be interesting to me to hear if it's the general impression among proceduralists, if that is a spectrum or subdiscipline of law that has a natural orientation to one or the other of these poles that I've created. The trick might be in answering that question is to at least do yourself the favor of challenging yourself with Frankenberg's tools. Before you answer this question, do a little distancing and ask yourself, before I answer the question, is procedural law tilted towards universalizing tendencies or particularizing tendencies? What is the epistemology of my legal tradition? Just so I know that before I answer the question. And then he would say, make sure that as you hear the procedural answers, that the answers about procedural law from different jurisdictions, allow them to speak for themselves. Don't simply look to have them say what you expect or what you anticipate. So that's both a question back to this community. Is it the sense that procedure leans towards one or the other of these poles? But it was a challenge as well. Before answering it, engage in that exercise of positioning yourself as the asker, as the person asking that question. I don't know if I've ended up answering or responding to your concerns, but I would like to hear you respond. Maybe if you feel like it to that initial question. Is it your sense that procedure is somehow uniquely susceptible to universalization as opposed to maybe the substantive law of murder in jurisdictions?
Now I'm getting very cautious, and I would say depends.
Yeah.
So what we have seen are sometimes trends, of course, many differences in detail, but trends to some methods, approaches. One example is ADR, which has grown up around the world. Collective redress might be another example, but also access to information has been inspired from parts of the world, and there are some tendencies. Of course, we have also other areas where we are distinctively different. But your reaction saying distance yourself before starting asking seems me to be a very valuable approach. But one should nevertheless start afterwards.
Yes, yeah. That none of these methodological challenges are meant to prevent us from going forward with the work that we've set for ourselves. If I can quote Legrand, of course, he always says all of these challenges he poses to us will fail at fulfilling his standards, his expectations. But he says we'll have failed better than those who don't ask these questions. So I guess that's my appeal in life in general. I'm trying really hard to fail better.
Thank you.
It sounds like some of the methods that some of your reactions to the question point towards a range of the methods I described on the universalizing side, a little bit of problem-driven, maybe functionalist approach, legal transplants. I heard you sort of hinting at the possibility of legal transplants. And that's not meant as a critique. I am sensitive, and I think Genevieve and I were sort of hinting at this, at whether we have to accept all the most severe claims of the functional method. That presumption of similarity, for example, seemed unnecessary to me for the integrity of the method itself.
And other claims too. But I would rather give now the floor to Ramon Feldbrin in Chicago. Ramon, the floor is yours.
Thank you, Enrique, and thank you, Russell, for this terrific presentation and stimulating observation. I have a small question. I was wondering if you see any connection on a general level between a functional methodological approach to comparative law and an economic analysis of the law. Both, in my view, seems kind of interrelated in kind of posing a problem from an objective sort of way and trying to answer those in kind of more general level. And I would be happy to hear your opinion on that. Thank you.
Yeah, thank you, Ramon. I want to visit your library if possible, by the way. Yeah, I have the same suspicion that they are closely related, and at least on that universalizing side of my dialectic. And in fact, Spaman suggests that himself. He argues that, and this I found interesting, he argues that these large-scale law and economics style quantitative, that I'm lumping a lot in that label, but that spectrum of methodological work would be beneficial in support of the functional method. In that sense, it's only a supportive mechanism, and that the functional method remains dominant in his universe. So we would continue to pose our questions. Maybe he might even accept the strong form of the functional method, which is pose our questions, search for similarity, and these quantitative analyses, the law and economics approach, would actually give us a chance of fulfilling those more accurately, fulfilling that universalizing dream more accurately. So I see them related.
Well, thank you very much. I guess this last question makes me bring in a last thought. Maybe Russ, you can comment on this, which is that we're not to simply choose one of these methods, but we are still allowed to cherry pick features from different methods and build up our own method in a way, creating a new, if we use Glenn's idea, a new legal tradition, so a new method built upon different features. And if you want to comment on this, we could then close with your last words.
I haven't given formal thought to this, but as I was reflecting on this talk and thinking about your question as you were posing it, and I confessed this a little bit earlier, I think that's exactly what I've been doing is choosing elements of, say, the functional method, but emphasizing some parts of the culturalist method. I haven't wanted to, or even sought to, escape the gravitational logic of the functional method, the problem-driven approach to comparative law, for example. But I haven't wanted to adopt that stronger, the more robust form of it. I also find the ethical elements of the position that Frankenberg, maybe less persuasively because of his tone, Legrand, but the ethical position that they assume relative to sensitivity to and respect for the other, extremely important and extremely convincing, and really essential for my students, both in their life. It transcends work in the law in some level, the teaching of the embrace of diversity, for example. I've found various elements of all of these convincing, and I suppose I'm blending them a little bit as you describe it. If I had to confess to having rejected or having a sentiment of disregard for any of the methods that I presented, I guess it would be a big project I've been working on for some time now, on examining what I refer to as the taxonomy problem of comparative law. I find of the methods that I presented, it's the legal families tradition built around the logic of taxonomy that is most challenging. Let's put it that way. That's the diplomatic way to put it, is most challenging. One of the things I've discovered, of course, is that comparative lawyers resort to legal families, and that taxonomic approach aspires to align the discipline with, say, the objectivity of the natural sciences disciplines like biology. And my research has found that the biologists have long ago given up the dream of those of the logic and the integrity of those. They of course still use them pedagogically, but they don't pretend to believe any longer that there is such a concrete and real thing as these species. One of the phenomena is what they refer to this as interspecies variation now, where traits jump between species inexplicably, and so that's one of the methods that I'm least inclined, and that speaks to, at least for me, the really immense persuasive force of Len's work. So that's maybe the one I haven't sort of picked from and blended a little bit.
Thank you so much, Russell, for
such
your
a pleasure
contribution.
and honor to be engaged with all of you. Thank you for the invitation.
And thank you all for being with us. And we expect to see you soon in the next CPLJ webinar. We must say goodbye now and see you next time. All the best.
Thank you all.
Thank you.